Welcome to the Case Autopsy, the Verdict and Settlement podcast. Case Autopsy is part of the family of podcasts brought to you by Lawyer Minds. In this podcast, we explore recent verdicts and settlements from around the country to try and distill down the best techniques for you to apply in your cases. Here's your hosts, Mike Campbell and Chris Finney.
Chris, how are you, brother?
I'm good. How you doing?
Good, man. Who do we got coming up today?
So we got Michael Young. He's a longtime insurance coverage guy, extra contractual attorney here who I've been fortunate enough to come across a few times. It's always good, usually when you're coming in across his way. He's great to deal with. He's extremely bright. And I've been seeing more and more of him talking about coverage issues, talking about insurance claims handling. And I think he's going to be a great guest because it is unique for us to have the opposite side. He is a defense lawyer. He works for insurance companies on this podcast. Give us some insight. What are your thoughts?
I think it's great. And I like how you said it's you like it whenever you see him kind of coming your way or coming into a case. And there are defense lawyers like that where like, one, this guy's going to be a professional. It's going to be easy to work with. But two, I might have some real juice here because
I got somebody's attention.
Yeah, that's right. Because they're bringing in someone like Michael who knows, the lay of the land and exactly, you got someone's attention. Right. I think that we've had proliferation of, every case is a bad faith case and we're going to push it all the way. And what's resulted is some not great case law. And what I want to try to get out of this is, okay, how do we take a step back and try to figure out what is the best approach in dealing with the insurance industry? Not seeing them necessarily as evil, but as if we want to try to get the best result for our client, it might not be protracting a case out for 6 years. It might be convincing the insurance company that we have a legitimate case. And what does that look like? If that's possible. My cynical side says it's not possible. My naive optimist side says, let's see if it is.
We'll see.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
Hey, Mike, how are you?
I'm good. How are y'all doing?
Good. Hey, why don't you introduce yourself to our listeners?
Sure. So I'm Michael Young. I'm a partner at Reichardt Noce Young. Still getting used to saying that. Here in St. Louis, my background is primarily I do insurance coverage and extra contractual work, usually on the insurance company side.
So then you primarily are looking at cases that are either heading to or have already headed to a situation where the policy limits have been exposed, opened up, or the claim is exceeding the policy limits and the insurance company is concerned about having to pay out something over and above the limits. Is that fair?
That's some of what we do. A settlement demand comes in, or maybe there's been some claim handling issues, and we'll take a look at that for them and sort of give them our best advice. Here's how it looks, et cetera. So that's a piece of it. But then also, different kinds of lawsuits, slip and falls, auto accidents, trademark cases, those will come in and maybe it's covered, maybe it's not, and sometimes we'll be hired to take a look at that and give an opinion, should we be defending this insured? Should we be giving them full coverage subject to the limits? That we do that sort of work as well.
And are you primarily determining if the insureds should receive? So are you serving as personal counsel for the insured, or are you providing the insurance company with those types of coverage determination?
Yeah, every once in a while we'll work for a policyholder, and try to help them, find as much coverage as they can if there's no conflict with the carrier on the other side. But usually 9 times out of 10, I'm representing the insurance company in this stuff and sort of evaluating and giving them, so our best advice is outside counsel.
That's great. I mean, a lot of the people who listen to this show are going to think, oh, the big, bad, evil insurance company. So
that's right.
Hopefully you can pull back the veil a little bit and Well, you can help us sort of dispel that myth or reinforce it, or help us figure out how we can work
or
together.
Maybe both. Who knows?
Yeah, work together to find common ground.
Well, and this is, I guess, a first for us in that we are a non-plaintiff's lawyer, essentially, is on the podcast. And Mike has well, I don't want to confuse the Mikes but Mike Young has a stellar reputation, unlike Mike Campbell. No, just kidding. But
that's fine. That's fine. I believe it.
So I've seen Mike Young on cases probably he's been practicing better part of 20 years, probably, right? And
yeah,
most of the work that I've seen you kind of come in when I've been involved is almost behind the scenes. And is that kind of how it works for you? Is that you may not have direct, I guess, communication with the plaintiff's side, but you're more or less taking policies, evaluating endorsements, evaluating policies, language, exclusions, and then rendering decisions of covered claims.
Basically, yeah, that's more or less what we do. And our interaction, if we're interacting with plaintiff's counsel, it's usually because defense counsel for the insured can't do it. Because they have some kind of conflict or whatever. There's been some policy limit issue. Maybe they've done something. Maybe there's coverage issues, and they just can't get into that sort of stuff.
Yeah.
And
we've seen you on excess stuff, when a verdict's come down that maybe wasn't anticipated. And then all of a sudden there's Mike in the back of the courtroom at the motion for a new trial or whatever, and wants to have a word.
Always good to see Mike, it sounds like. Not this Mike, but that Mike.
Yeah. So what I'd like to do is kind of give a little bit of an idea of maybe you could, here's what I'd like to shed some light on. When I look at these insurance policies, I guess they're supposed to be understood by a reasonable policyholder or whatever it is. But we have you, who is arguably the smartest person we've had on this pod. You've graduated the top of everything.
I doubt that, but
Matt Sharp was pretty bright, but other than that, I think we're probably, so you're hired to look at these things. This is a difficult job. And I wanted to ask you a little bit, where do you see this policy language going? Do you see it getting more and more complex? Because I've heard, some mediators, some defense guys, some plaintiff guys say, listen, they keep carving in, taking out. One of these days, somebody's going to take a shotgun to the thing, just blow it up and start, eviscerating things. So I feel like you probably have walked that fine line on crafting policy language for people or advising of, hey, we're getting too cute or something like that. Is that part of what's going on in your industry these days, or kind of shed some light on that for us?
Yeah, I mean, it's funny because you look at this policy language, right, or a sentence or two, and you're like, why in the world would they write it this way? And they're like, okay, Michael, how would you change it? And you're like, oh, this is harder than it looks. Yeah. I think there's always this argument, it's been going back decades. We need to make these things simpler, easier to understand. And there's some insurance companies out there that kind of market themselves that way, that look at us. We have a very simple, easy to read policy. There's so many complicating things that go into it. Just first of all, people say, why do you have all these endorsements that are changing everything? Why don't you just put it in the main form? And a lot of this is like a regulatory thing, because the state has to, except for like surplus line stuff, they have to approve all these forms, so when you have a main form, they stamp that thing, so if you're going to change the main form, you have to go through that process. It's easier to get an endorsement approved than it is to change the main form.
Okay. So our main form, just for everybody, is the booklet, right? Your policy, it'll say, this is the policy. Right. And it'll be, for auto policies could be 15, 20 pages, something like that, or homeowners. And then that gets approved by the Department of Insurance for the state?
Correct.
Okay. And then now that's interesting that I didn't know, is it's easier to get an endorsement on there than it is to change the main form. So that's why I'll get those mailings every year of this has been changed.
Yeah, that's right. Because the regulators, if they're just looking at one page, that gets moved much more quickly than if I'm going to redo a CGL form that may be 35 pages.
Got it.
It just takes longer.
So then where does the insurance industry go? I guess the casualty lines go when it comes to, I like to call it reactive language or changes. A case comes down or a claim comes down, and it may be a small, it may seem like a unique situation, but then, we'll get a mailer that said, a policyholder gets a mailer that says, hey, this is a change has affected your policy. Please read this endorsement and replace subsection C part 1 with this. How often are you seeing that? What's your thoughts on those reactive changes or things like that when it comes to, making the language changes?
Yeah, I think that they tried to do that, because what they're trying to do, they will say, is they want the policy to match their intent. However they price this thing, the actuarial people, you're like, this is what we think we're covering. And then a case comes in and says, no, you're not. You're doing this. And they're like, well, that's not what we meant, and so they'll try to change. I mean, like the biggest example, Chris, like in our Missouri stuff, was on underinsured motorist coverage.
Yeah.
And over the last 10, 15 years, when the liability carrier pays its money, the UIM carrier, if you will, they want a credit, right?
Yes.
So what does the credit come off of? Does it come off of the damages or does it come off of the UIM limit? And, the Missouri courts interpreting this language saying, no, there's an ambiguity. You don't get the credit off the limit here, but then another court says, well, you can if you write it this way, and so all the companies look at that, and they make a decision. Do we want it to come off the limit or not? Because do we want to be competitive that we can say, hey, it doesn't come off the limit, or do we, you want to be more restrictive and we're going to have, cheaper policies, wise, and so it's this constantly, looking at these cases and making these sort of decision. Does it match the intent of what we thought we were selling?
And that's what I found more interesting over the last couple of years is that UIM is that it was going to that point to where it was off the policy limit, right? They say, hey, you get a credit. We get a credit off your UIM limit. So if you have $250,000 settlement, you got $100,000 UIM, you're not going to get your UIM. It's not underinsured by definition. But then I've seen a few from maybe, I don't know what they're going by names by now, Safeco or Liberty Mutual, maybe, where they have some damages endorsement language, I think, is what I've seen recently. I don't know if it's still like that, but I mean, I noticed that as a lawyer, it's like, holy, wow, that's a good, I'm protected if I'm buying an underinsured,
right?
Endorsement. That's what I want. But does my question, I guess, a lot of times is what's the regular person see? Because the agent is the one who's kind of usually selling them this product. And that's where I guess our biggest frustration is people think they got something, because an agent who it's not spent as much time as you looking at these things and crafting it. And then they come to us and like, I thought I was covered. And then we get a letter from someone that says, actually, the intent of this policy was A, B, and C. Right. That's excluded. What's your kind of take on how the agents are moving these policies, placing these policies, things like that? I mean, do you have any thoughts on that? Because that's for the regular consumer, I think that's a real big, they just think you get off 15 minutes, save you 15% or less, that type of stuff. And
because
probably should spend more time.
Yeah, because I think the average consumer, for the most part, they're just buying this based on price.
Yeah.
Right? The commercials are interesting, and so forth, and the different slogans and all these things that they say we're going to do that then later I have to defend in bad faith cases what the marketing department has told us. But it's just one of those things where it's just such a challenge, because you're looking at this stuff and trying to see what fits. It's a real challenge.
So when you get walk us through kind of like you'll get a referral into your office and talk us through exactly how you're going to evaluate a policy top to bottom to see if a claim's covered. Like what's your step-by-step process to look at the policy and make decisions?
Yeah, I think the first thing that we do is the carrier will send us the policy and they'll say, this is the policy, or they'll say, this is certified policy.
Yeah.
I'm like, okay. But we always got to look at the deck pages, right? Because the declarations page on every insurance policy will list all the different forms that are supposed to be included. And we always check that, because you'd be surprised how many times they say this is the policy and it's missing an endorsement, a key endorsement. So we always got to look at our table of contents, make sure we have everything.
So deck page, I don't want to cut, but you start at deck page and that should list every coverage you have.
Correct.
including endorsements.
I like describing it as a table of contents. That's really great. Yeah.
That's how we kind of see it, because I mean, it tells you who the insured is, what's your policy period, what's your policy number. It'll actually, because most insurance policies, the forms, whether it's the main form or the endorsements, they all have like a little code on them. Like ISO puts on a code, or whoever puts these codes on. Well, those codes ought to all be on the deck page. So you always got to check to make sure, do we have the right deck? Do we have the right year?
Policy period's a huge one, right? If you're going back, you get the wrong year and the language has been tweaked and you're like, hey, we're looking at the wrong, that's not what this said in 1999. It might say it now, but not
that's right. I mean, there's nothing worse than spending 2.5 hours trying to figure out coverage and you have the wrong freaking document.
I've definitely done that and been like, wait, this is current, not last year's version.
That's right. That's right. And it can change significantly. And so then once we have what we think is the policy, then it's literally, Chris, like you say, top to bottom, and you just start with the first page and you just flip through it.
Yeah.
And I kind of flip through the whole thing and get a feel for it, see what's there. Because after a while, when you do this, you start to look for certain things. So I'll just go through it, and it's just literally, is the insuring agreement met? Great.
Yeah.
Are there any exclusions, provisions that take away coverage? Do any of those apply? Are all the conditions met? I mean, it's literally going through, all of that stuff, comparing the complaint or petition, whatever extrinsic evidence we have in Missouri, and just trying to figure out, how does this look?
Do you take because when I used to work for a 2 year, or no, not 2 years, not even close, 6 months of insurance defense work, but the guy I worked for or worked with did a lot of coverage work. I thought he was very good. And he would start with the idea of let's just start with everything covered. Like whatever this act, let me assume it's covered and then dive in. And then we can, goes narrower as we go down. Is that the right approach, or is that a little bit too broad, a little too simplistic?
People do a different way, because I think the standard is for most states is, you have the policy language, and do we have in a liability case, do we have a duty to defend the suit? That's one standard, very broad. Do we have a duty to indemnify, that is, pay a judgment or settlement? That's a little narrower. And you're literally just looking at the language and trying to see, is there coverage or not? But people, when they do that, though, they have different philosophies. And like a common one that you hear, that I think is good, that a lot of the people in the industry do is they try to find coverage. I mean, that's not the law anywhere. We try to find, but I think that's a good approach. Like, look, there's got to be coverage here. Where is it? And so if you come at it with that approach, you're looking for stuff.
Yeah.
You're looking, is there any personal and advertising injury? Stuff you might miss.
Yeah.
But if you're focused on going through, well, no, it's not this. No, it's not. Okay, maybe it's this.
You're trying to.
I think a lot of people do it that way. You don't have to, but I think that's a good way to do it.
And I like that. That makes sense, because what you have, really, insurance is a product, right? And you're trying to maximize that product, your value for what you paid for that product. So when you're doing that, so say we're looking at that, and you have an individual insured, and you're retained by the carrier. There are probably tough decisions you make about coverage. I mean, you're the guy they go to make, that's why you get paid to do those jobs. What's your mindset when you're making those decisions about close calls and coverage, but it's really not there or whatever? And it could be a horribly catastrophic case.
Right.
That's what I'm really curious about, right? Is like, hey, this is stuff I've never talked to anybody about, and I'm curious what your thoughts are when you do that.
Yeah, you have to start with what's the jurisdiction. If I'm going to have to litigate this coverage issue, where's that likely to be? What is that motion judge like? What is that appellate court going to be? Am I going to be in federal court? Am I going to be in state court? And so that kind of guides the analysis, to a certain extent. Who's my decider? A lot of these issues, I mean, it's Missouri, we're not in Illinois, right? So we don't have a ton of case law on insurance coverage stuff. And so there's a lot of issues that we just don't know what the appellate court is going to tell us. We just, I tell clients sometimes, we'll know when the appellate court tells us, but you do, I think, try to spot trends. Is this language like this? Do we have a couple competing exclusions? What have the courts done with similar type things? Where's Missouri going generally? Where's Illinois going generally? You try to look at trends, you try to look at the jurisdiction, you do look at what other states say. My experience is that a lot of our judges really don't care, what Kansas or New York or West Virginia says on this stuff, but it's helpful.
Yeah.
If you have an issue, like an uninsured motorist coverage, like the horse and buggy thing, we're in different Amish countries around the United States, is a horse and buggy, is that a vehicle, that qualifies for uninsured motorist coverage? And it's all statutory, but every single state has said no. Okay. That might be an instance, and Missouri's even said no. That, let's say Missouri didn't have an answer on that. If I could say, hey, look, 17 courts have all looked at this, they've all said there's no coverage here, or what makes us so special?
Yeah.
Or on the flip side, so you look at, national trends like that as well.
So then on like the damages side of it, though, when you're doing that evaluation analysis, I know you're a dad, you're a husband, you're very personable, you post great stuff on LinkedIn that I enjoy looking at and reading. What is your kind of psychological framework when it's like, hey, this is going to suck because this is a really catastrophic case, but the intent of the policy wasn't there? I mean, how do you, because you deal with big claims. I mean, you deal with large losses and very difficult coverage disputes. I've been on, maybe one or two of them with you, but when you look at that, how are you approaching that? Because our side, we always approach human, this person was horribly harmed. Somebody's got to pay for it.
Right.
Give us the benefit of the doubt. Obviously, you can't always do that. That's not feasible. But so how are you handling that approach?
Yeah, it's apart from the human side of it, because sometimes it can be very difficult.
Mm-hmm.
I mean, I've had cases where I look at it and I'm like, gosh, what happened to this plaintiff is horrendous. How can there not be coverage for it?
Yeah.
And that's tough.
Yeah.
That's tough, because you see people that get paid on claims and that they shouldn't. And then you see some people that should and they don't, because there's no insurance for it. And it is very difficult. I think as far as like just the analytical piece of it, though, maybe it's that old thing, bad facts make bad law.
Mm-hmm.
And there was I think it's from our Supreme Court in Missouri, there was a case, is uninsured motorist coverage, and it was some horrendous thing where the plaintiff was in a vehicle and that drove over the decedent, which was like a relative, and they knew it, they could hear the screaming, and it was just terrible. But the plaintiff themselves had no physical injuries, just pure straight up emotional distress. There was nothing physical to it. And the Missouri Supreme Court said that's okay, that's good enough for bodily injury under the UM statute, just straight pure emotional distress, which is sort of I think a minority position on that UM stuff. But it's an example of like, the courts are going to look at these facts and the notion that that we're just plainly reading this stuff and it's going to be applied perfectly, literally. Judges are human too, and I do think that affects the analysis, and so that goes into our thinking too.
Yeah.
Like, look, we think this is a really strong coverage position, but like this plaintiff died of a fire.
Yeah.
So like, what is the court going to do with that? And I do think it affects things, rightly or wrongly. I think it does.
And yeah, that you make a good point about, bad facts make bad law or whatever. Is like you also are evaluating, well, we might be in the right position on the policy, but these facts can be read certain ways, by the judges who are writing things in the appellate court. It could go the wrong way. So you've got to advise those. In terms of, some of the more unique cases, I kind of wanted to get your take on the STD case. I know you've written about it, you posted about it. For those that are not aware of that one, kind of give us the procedural rundown. I don't think you were on the case. I don't know if you were, but kind of give us a procedural rundown and why this made the national news everywhere.
Yeah, I think it made national news for the wrong reasons, actually.
Yeah.
Because this was, and I don't know, I haven't read the case in a while, but it was essentially, a plaintiff suing, I don't know if it's a boyfriend, fiance, whatever it was a sexual encounter in the car. She gets the STD. She accuses him of negligently transmitting the STD, right? And so I think this was one of these before they changed our statute here in Missouri, 537065. I always tell people, Chris and Mike, when I speak to insurance companies, I say plaintiff lawyers in Missouri know two numbers. One is 8675309 from the Finney song, and the other one is 537065, right? Because this is statute, that lets you guys, do an agreement with our insured, which basically says if I get a judgment against the insured, I can collect against the carrier only. It gives the insured tremendous leverage. Sometimes there are findings of fact showing that there's coverage. It's funny how those things work out like that. And it's just been a battle royale in this state for at least 10 years. So this was, I think, under the older version of the statute where you also had this amazing arbitration process, right?
And that was the big one people would utilize. And
yes, that's right.
Use it too many times and it catches the attention of everybody. But yeah,
that's right. Because under the 17 version of our statute, the carrier, if the stars align correctly, could intervene into the case. The thought is to participate and prevent what the industry feels are like these set up consent judgments.
Yeah.
And so then brilliantly, the plaintiff bar came up with this arbitration process. Like, well, how do you intervene in that? And do you even want to intervene in that? And that was a whole debate. And so I think that the judgment here ultimately was the product of an arbitration where the arbitrator said that, yes, defendant negligently transmitted an STD over to the plaintiff and, went up to the Supreme Court and they reversed on some super technical timing stuff. But I think essentially at the end of the day, that arbitration was going to hold, right?
Okay.
And but the problem is though, is why it got attention is because it was widely reported that the judgment, said that there was coverage for the loss.
Yeah. Okay.
And it was an auto policy.
Yeah.
And actually, if you read the judgment in the arbitration, it didn't say that at all. But everyone reported that, like the BBC, if you can believe this, of all people, they're reporting on people having sex in the car in Missouri. It was unbelievable. But it didn't actually do that because there was the separate federal proceeding, deck action, I guess, that was going to rule on the coverage. And I think what happened here is that the judgment, yes, said it was negligent, but it left out a key fact, and that is to get auto liability coverage, the injury can't just happen in or near a car. The car has to be an instrumentality in the loss. It has to somehow have something to do with the chain causing the injury. So like if there's a drive-by shooting, just because someone shoots someone from a car, that doesn't make it an auto liability case. Like the car has to be used somehow to cause the injury. And that fact was left out of the arbitration court.
Got it.
So then it let the federal court do what it could do and say that there was no coverage for it because they said there was no, the vehicle itself didn't give rise or whatever to the plaintiff's injury. So, they left that fact out and what gave the federal court some room to find no coverage,
Yeah. And so
then it's just crazy. I mean, it's a Missouri special because it's got sex, it's got cars,
right?
It's got coverage.
It's got 065.
It's got 065. It's got arbitrations. It's got these bizarre technical rules.
Yeah,
I mean, it's a truly Missouri special.
It's like all for nothing because the federal court was going to found no coverage. So it's just like a big old piece of paper that looked cool.
Correct. Ultimately, it did. Now, if they had put a finding of fact in the arbitration award that said that the vehicle was somehow an instrumentality in the loss, that would have been very interesting to see what the federal court does with that.
Got it.
But it wasn't decided, and so then Uncle Sam could review that.
Well, so I won't get a change in my policy that says sex in your car. This is not covered arising out of the use of the vehicle.
That's right. I've not been reviewing many, backseat endorsements, on the other policy.
I like that.
Yeah. And I think it's important for our listeners to know too, especially it seems like the more that plaintiffs' lawyers, newer plaintiffs' lawyers find out about the idea of bad faith, they think, okay, well, I'm just off to the races. Everything's bad faith. When in reality, in a case, especially like that, I think it was the Geico was maybe the insurer there.
Yep.
They would actually have to prove it's a double proceeding. They would have to prove that there is coverage and then they would have to prove that actually bad faith existed, and that's intentional or outrageous conduct. So it's, even if the deck action wasn't going, they would still have to prove that there was coverage under Missouri law. Is that, I mean, I think that's an accurate summary, even without the deck action.
Yeah, I think so. I mean, one of the tremendous advantages that the plaintiff bar has on these bad faith cases and liability is this notion of hindsight bias, right? Because when the insurance company gets the settlement demand and they're not paying $100,000 the limit, hopefully they're doing it because they don't think the case is worth 100, right? And based on their investigation, they look at it, whatever. But when the bad faith case happens, the jury, now we have like $1 million verdict.
Yeah.
Right? We didn't pay 100. Now there's $1 million verdict, and a jury, they know
both.
They know the answer.
Yeah.
They know, we didn't pay, and now there's
we know you messed up. Yeah,
that's right. And it's this notion that it's like, oh, this was inevitable, right? Like, you could have paid 100, now it's $1 million. You're an idiot. Of course, bad faith. And so it's such a huge advantage, and so the carrier bar has to do the job of like explaining, no, here's what the universe looked like when they turned this down. And a lot of that depends on how good my file is.
Your claim notes.
Yeah. What do the claim notes look like?
You're a big one on claim notes, right? It's like, kind of tell us what, like, this is what I think is really, because claim notes are like the text messages to me of a insurance claim. Right. And somebody like you is going to have to piece together what they meant after we've gotten this big verdict or something against us, right? Or against you.
That's right.
And so tell us what's the importance of those? Why are you, seems like lately you've been nailing on LinkedIn, like this is not, what would you do with this claim note? It says like, talk to insured, period. Right. It's like, so to kind of tell us, give us some insight into that.
Yeah, well, because the claim note piece, it's a lot of states like Missouri, like Illinois, on liability cases, for the most part, those are discoverable. In Missouri, we have this Griel case, we've got to turn it over.
Yeah.
Maybe there's some exceptions for coverage, who knows? But like for the most part, these claim notes are being turned over, and the claims professionals, they're at their home, they're at the insurance company, they're dealing with you, they're getting medical, they're talking to witnesses, and they're at a laptop, or a computer, and they're just typing this stuff. And so it's very easy for them to think, well, these are my notes, right? Or like maybe my supervisor is going to look at it, and they don't understand, like, no, like what you're doing, you're making an exhibit.
Yeah. When
you're typing this stuff. And, you can really help yourself by doing a good note because number one, it'll show you're doing your job. But then number two, when you and Mike depose the adjuster, it's going to be 3-4 years after they made this decision.
They won't remember anything. It's impossible.
They won't remember anything for the most part.
I had 1,000 claims since then.
Yeah. And so like the claim notes is the file for the most part, and so having good notes they can look at and say, oh yeah, I talked to Sam and Sam said the light was red. That's why we didn't pay the demand. If that's not in there, then boy, is it a challenge.
Yeah. Well, so I got two thoughts. One, the only thing I'll push back on a little bit about the plaintiff's bar having an advantage is that when you're viewing something like claim notes or claims handling, we don't say that it's negligent claim handling. I mean, we have to prove that it was an intentional. So it's so they're a little bit different than any other professional, right? And in the state of Missouri, we don't view it through the lens of a negligent standard of care.
Yeah, it's different states have different standards,
right?
Like on the one, like Connecticut, in New York, like that, those are very difficult standards to show bad faith. I mean,
very
that's
difficult.
Like, you have to like prove intentional dishonesty.
Right.
Right. And then you got Florida on the other end, which is kind of a negligent state. But, and so where does Missouri fit? I would say it's closer to the Florida than to the Connecticut. But
I agree. Okay. And I'll concede that. That. Yeah. It's, and it's always one of those things where it's like, we'd like for the insurance company to come in and say, we weren't intentionally doing this. We were just negligently doing this. That would be a very interesting argument. But from the
I was going to say, does that play real well?
Yeah. No, I can't see it working very well anywhere, but yeah, we'd love to see it. We'd love to see it sometime.
That's right. We didn't try to shoot the guy.
Yeah, exactly. It just was. It was
got
in
the way of the bullet.
Yeah. Well, so let me ask you this: from a plaintiff's lawyer's perspective, if we are wanting to give the insurance company every opportunity to act in good faith, what are some of the things that you would suggest if we're, because you're talking about, from a claims handler perspective, creating one, it's just good practice. And that's what I tell plaintiffs lawyers, just good practice to send plenty of letters and update, notify, and let them know what the claim is about. Are there any tips you would have for us, not about creating exhibits, but just the idea that we want to try to inform the insurance company of our client's situation, and we want to try to get this resolved correctly? And also, if there is some sort of bad faith component to it, we are putting our client in the best position possible to have that sort of claim.
Yeah, I guess it depends what your strategy is with the claim, and are you trying to get it settled ASAP for the limit, or are you trying to see if we can maybe we can make a bad faith case out of it. It really depends on your strategy.
Yeah.
But if it's just a straight up, we want to get paid the limit ASAP. The best thing I can say is give them what you got. Give them all the medical. Give them all the bills. Don't give the carrier any excuse for we need more time to give them what you have. Because honestly, that will speed things up. Because if you have a $50,000 limit and you can show them what this person's had surgery, the medical's $250,000. Here's the bills. If you send them that stuff, that's going to get paid.
Yeah.
Now I know like sometimes plaintiff lawyers will hold back information, and it drives insurance companies crazy. Like, or you'll give us a piece of it, but not all of it, and they're like, why are they doing that? I'm like, why they're doing that.
Don't know any. I don't know. What are you talking about?
Yeah, no, maybe I've just made that up. But that goes on too, and because I get it, because you represent your clients, and if you have someone very badly injured, $50,000 is going to do anything for them,
right?
So I get it.
But it is fascinating though, because I always try to encourage people, if you're thinking about this, and correct me if I'm wrong, but if you on the other end, I was kind of poking fun at an insurance company saying, oh, we didn't do this intentionally, we did this negligently. But on the other hand, if we have to try a bad faith case, we also have to show, we have to convince a jury, hey, we gave them opportunities to try to work this out, right? And right. What is that? I mean, my argument always is if you think a jury of 12 people is going to look at one letter with like 2 sentences on it to say, pay me because X. I mean, what if you're looking at it from that perspective? Would you encourage plaintiffs' lawyers to, hey, try to do what you can, but make sure that you're looking at it from a 10,000-foot view? Does that make sense?
Yeah, I think so. I mean, it's I guess to a certain extent, the plaintiff will be judged based on the reasonableness of the lawyer conduct. And if it looks a little too gamey, some juries not.
That's where I was going with it. Yeah.
That's like, oh, come on. Like, really, the plaintiff really handwrote this demand. And then 2 days later, the plaintiff lawyer comes in with their own letter. I'm like, come on, but,
what are you talking about? Handwritten?
Yeah. I think I saw that once. But on the other hand, juries, I mean, are insurance companies their favorite people?
No.
Because here's the problem. Like, so many people, I think, I'm like, you guys have a view of carriers because you got to, you're dealing with them all the time. I think a lot of normal people, normal meaning non-lawyers, not litigators, whatever, they see the insurance industry, like their interaction with insurance is with their health insurance.
Yeah.
Oh, yeah.
And it's like, God, I got to pay $200 for this MRI. This is ridiculous. And so I think in like the health insurance industry and liability care is completely two different worlds. But like normal people, they don't know that.
Mm-hmm.
So there is this tremendous bias against carriers as well. So that's the other thing we have to do also, is try to humanize these people.
Yeah.
Like, here's my adjuster, Sarah. Do you really think she's just trying to do her job,
Sarah has 3 kids and is working out of her basement. Like, she didn't, you think she was out to get Mike Campbell? Like she was really wanted a piece of,
Yes.
So
That's right. She doesn't get any. She doesn't get anything out of this. She's just trying to do her job.
Right.
She's not profiting by this. I mean, she's not trying to hurt anybody. Maybe she just didn't respond in time. Whatever.
So that leads me into the next thing I want to ask you about, and is something that we see, I think, a lot on our side. Probably you see it on yours. Is adjuster workload. It used to be. Probably before you started practicing, before I started practicing, you had more boots on the ground type adjusting, stuff like that. And then the industry went to more centralized offices.
Right.
You mail, scanning for mail. They all go to a center. We don't know the adjuster. You may know an adjuster a little bit, but you don't. The days of them bringing 5 or 10 files to your office, you guys going over them, working out some kind of deal on the merits of all of them and clearing off those claims doesn't really happen anymore. You're usually dealing one-offs with different adjusters, and they seem to be, I'm trying as empathetic as I can be to an insurance carrier, very overworked, where they have limited resources, and they're sitting on their laptop trying to read 1,500 pages of records, and somebody else is calling them, yelling, "Hey, I sent you this demand 3 weeks ago, 4 weeks ago, haven't heard a word, didn't even know you got it, didn't get scanned in, they don't know where it." What's your thoughts on the adjuster workload, how that's where do you see that headed?
I think the industry, the insurance industry is in a tough spot right now because they're just like every other employer. It's hard to find people who want to work and do some of these jobs.
Yeah.
You go to McDonald's, the drive-through line is forever because they can't get people to, cook the fries. The dentist office, the accountants, it's hard, the accountant offices, they'll tell us we can't find people to help process these tax returns.
Yeah.
And so the insurance industry is in that spot. And so what they're trying to do is trying to make these jobs more attractive for people to want to do coming out of college.
Okay.
And starting to work with the universities, doing the job fair stuff, doing the flex time, work at home, all the kind of things that we're all doing to try to get good people to work with us. That's what they're doing, but it's tough to fill some of these spots, and claims don't go down.
Yeah.
And so you have a lot of people, working their ears off trying to catch up, until we can really hire some more people to get things fully staffed. So I don't think it's a cost cutting like, hey, let's get rid of 20% of our staff to save money. That'd be insane.
It's just workforce.
Yeah, they're like begging people to work for us.
And it's a tough job. It is a tough job because there are people they deal with, for all the cases they have, there's a me or Mike Campbell on the other side, or somebody from our office who has a client calling them saying, "Hey, what's the deal? What's the deal?" Right. We then call them and say, "Hey, what is the deal? What is the deal?" And they may not have an answer from a higher up, from a round table, something like that. And so it's just this game, or not a game, but it can lead to a lot of frustration. And probably some of those lower level guys are like, "This is not worth it. I just got blasted by this plaintiff's guy for something that's not my fault."
That's right. And then the temptation is once you go off on them and they hang up the phone, now they got to type a claim note.
Yeah.
Yeah, exactly.
Yeah,
and they're furious at you. And I'm like, don't type it. Don't.
Yeah, you should type it all.
So Mike, I'll get to yours, but I did want to ask, the one thing that a lot of people are interested in on our end, or at least I am, is the round tabling. And you see that on a fairly regular basis on a certain value, certain level of claims where, hey, I'm going to round table this. And usually, and this is what I want to ask you, how can we make that adjuster our advocate? Because no adjuster wants to be the one that made the wrong call and offered 50 on a $750,000 verdict. You know what I mean? Like so, how that's where I think a lot of us, myself included, are missing opportunities to maximize recovery in a shorter time frame by not making that adjuster our advocate. What do you recommend other than, hey, give them everything you got? Like, can you give us more beyond that, or what?
Yeah, given what you got, the other piece is the timing of it.
Okay.
Like the timing. Now again, Maybe you want to put short time deadlines on it because that's your strategy for, doing whatever. But again, if the goal here is to get the policy limit and close the file, it is giving them that time, because depending on the company, like the roundtable, maybe they roundtable every other Tuesday.
Oh, okay. They're not. Yeah, gotcha.
Yeah, so if you put like a 10-day demand on them, it's like, I can't do anything with this.
Yeah, and so-and-so's out of town that Tuesday, and he's one of the money people or whatever.
That's right. So even if I want to pay this, I can't do it, and so, so if they're asking for that more time, if you feel that it's genuine, that they're not just kicking the can down the road, I'd give them that, because from your perspective, it's like, it's not bad to say, I gave them 18 extensions and they still didn't pay it.
Yeah.
But for them internally, having that time so they can process that, have that conversation, go to management. Maybe management's got to go to management, depending how big a case it is. That timing aspect of it can be big. And like I said, giving them the materials, giving them the bill, so that they, so they have no excuse.
That's kind of what I want to dovetail on a little bit with Chris's, because if you pull back a layer some, I never had any experience in the insurance industry. Once I started doing a lot of auto, I would get really frustrated. And then whenever I started deposing adjusters in bad faith cases, it became really evident to me that there are structures to this. So could you walk us through, so if there is $100,000 limit and you've got the casualty claims adjuster getting that information, what would she have to do in terms of speaking with the person above her, just generically? It doesn't necessarily have to be one insurance company over the other, but in terms of her reserve, what her authority is and that time frame. Because I think a lot of people want to have those, big bad faith cases, but there are a lot of people out there too that are like, I just want the insurance company to understand that this is a policy limits case, or I want to get fair value out of this case for my client.
Right. Yeah, I think it just depends on the company, because you will have some frontline adjusters who have quite a bit of authority and can settle cases up to a certain dollar limit. You have others that just don't.
Right.
I mean, their authority may literally be $10,000, $25,000. And so, and it depends. Sometimes they have to type up claim notes. Sometimes there's reports. Sometimes they have to present, at a round table or, a claim committee. It just really depends, and so from your guys' perspective, giving that person as much stuff that they can go before, here's the case, the medical is this, the injury is this, the limit is this. If we try this case, in Jackson County, here's the lay of the land. Here's, we have this coverage issue. Okay, but we're in the Western District, and what are they going to do with it? Mm-hmm. Being able to have them to make that case is huge. And the problem is, it's so easy for them to say, oh, I can't pay this because I don't have the stuff.
Yeah.
I don't have the stuff, and I always say, well, okay, fine. Ask for an extension, and if the plaintiff is good with that, and say, here's why I need the time, 1, 2, 3, 4, 5. So many times you'll get those letters back from the carrier that's like, we can't respond to this now. I'm like, okay, and then what?
Yeah.
So it's always like, my advice is always, let's bring this to resolution one way or the other.
That's what you said there is because that is how I feel sometimes. Is they'll say, hey, I need X. Okay, I'll give you X. Oh, I need Y. I can't give you Y. Like, well, I can't respond yet. And I'm like, why can't you? Tell me why you can't respond. And I will, I want to be reasonable. I'm not always reasonable, but at least give me something I can tell my client who's like, hey, this is the third time now you told me they were going to have a response and they don't. What's the deal? And I think that is one of the places we lose. Communication breakdown happens. Yeah. We don't tell them, what we're really looking for, what we have, or maybe we really don't have something, that they want, and we don't explain why it's irrelevant to the case. And then we don't get the response of, well, I need more time because A, B, C, and D. And sometimes I'll get that I need more time because I need to evaluate, I don't know, their Social Security disability from what I'm like, that doesn't have anything to do with this, claim, but at least it gives us some conversation. But like you said, the 2-line letter of, well, this is not an acceptance or a rejection. We're still evaluating and need more time. And to me, that's where like the steam comes out of my ears because I'm like, what else do you need? I'll give you everything you want. I'll drive it over to your office that now doesn't exist, but I will send it to Arizona if that's where I need to send it. So
I can understand. I mean, it can be very frustrating.
Yeah.
It's like, yes, you need more time. Yes, you need to look at more stuff. Okay, well, what is it?
Yeah.
Maybe the plaintiff has it.
Yes.
Well, why did we'll just ask them? Know?
Or they can easily track it down. Oh yeah, they do have that stuff. I think that is one of the more interesting things. And then, part of the thing I think is sometimes we are speaking different languages. I'm not a big special items of damage person. I know that usually frontline adjusters are looking for specials, and I know they are to justify their recommendation to their bosses.
Yes.
And to me, that's one of the biggest points of friction going on right now, is the non-economic loss. What are you seeing on for you guys and stuff like that on your side?
Yeah, it just depends. I mean, I think there are a lot of adjusters that do look at those specials. They want to see those numbers. Mm-hmm. It's the culture. It's how they evaluate these claims. And when we talk to folks, it's like, okay, but is that how juries are evaluating cases? Because if you're evaluating according to a standard that the juries aren't doing, does that make the most sense in the world? Mm-hmm. Now, whether it's that's the best approach to evaluating the claim or not, if that's what they say they need, if you give it to them, okay, then what? Then you can have a debate over, okay, now I gave you this stuff. You say you need it. Here's your evaluation. Here's why you're wrong. 1, 2, 3, 4, 5. Then you can have that conversation.
Yeah.
Because that's how so many of them want to talk. So to get that conversation going, give them what they need to start it.
You almost got to it's like when people come to a group setting and they say, all right, let's check in with everybody. How you feeling? And everybody gets it out. As long as you can get out the specials, you can set that and move it off the table. Now you've gotten that. Let's move to where we're where I think the discussion's about.
That's right. That's right. And it may be frustrating. It's like, why do you need this?
Yes.
Like, this is crazy. Why do you do just, it might be like, just give it to them, then we just kind of start talking.
And that's part of the problem.
This is perfect. Yeah. Because you're like tracking everything where I'm going, which is like, no, I want to talk about human damages. I don't want to talk about.
And that's the thing is like, we don't spend a lot of time getting bills on our end now because we're not putting them in a trial most of the time. And so we're not going to waste the time to get every little bill or something. And then you have the adjuster asking for them. And you're like, damn it, I didn't get them. And now it's going to be another 40 days because this carrier, whatever this healthcare provider is a zoo over there and I can't get them and blah, blah, blah. Now, then the frustrations kind of overflow. And then now there's no communication between the adjuster and the attorney, or the phone calls are being ignored, and rightfully so, probably from both sides. Either somebody's upset or, and then he's moving to suit, which becomes more expensive and
right, which is just more expensive and time consuming for everybody.
Yeah, and then you're kicking the can further down. We all think alike at the end of the day, right? It's like how can we get this move?
That's it. It's how can I communicate? And thank you for answering the way that you did, Mike, and thank you for clarifying that, Chris. Those are the frustrations that I have too. Is look, I understand you're looking at the medical bills and you're doing this calculation in your head, but let's talk about how my client can't pick up his kid every day she comes home from school, and that was something that they enjoyed doing, playing kickball or swinging or giving her hugs. How is that? You may have already answered, but I kind of want to ask it again. Like, how best can we communicate that? I mean, what does that look like from the insurance company's perspective when we say something like that? Is let's talk about what happened to this person beyond the special items of damages, the medical bills, the lost wages.
Yeah, I think and a lot of you guys are really good at this with the demand letters. Like you'll go through.
So those make a difference, honestly, because I go back and forth whether they make a difference or not.
I think that they do. When you explain, here's who this person is, and here's how this accident has changed their life, and the damage it's caused and so forth. I think it does. Because when we go to mediate, I can say this. I think a lot of the insurance adjusters are, what does the plaintiff look like?
Yeah. Yeah.
What do they act like?
Yep.
What can we glean from this? And it's like, well, you had the demand package, we had a video or whatever. I do think that stuff matters.
Yeah.
I do think it does. Now,
and if they're consistent,
yeah, I think it does. Particularly because if that's the argument you guys are making, giving that to the company so they can look at like, do we want to try this thing?
Mm-hmm.
Is this really, do we really want to litigate? Hey, is this proposed surgery? Is it really necessary or not? What is that going to look like? What does this person look like? How has their life been changed? I do think that stuff matters.
Okay.
Yeah.
It's really interesting. It kind of, again, it's about the breakdown in communication, reestablishing lines of communication. I'm thinking about like maybe a soft tissue case where person has aches and pains, never had them before. And let's say there's $1 million policy. And, Chris thinks that's a $5 million case. I'm in rural Missouri. I'm like less optimistic. Chris is cheerleading the case for me and saying, no. But you want to basically explain to the insurance company who this person is. I like the idea of including pictures and stories about the clients in the demand letters. Now that I hear that those things are actually getting read.
Yeah, they're for 100% being read. There's no doubt.
Very interesting. That's good. I like that.
That's because I think I've seen and that's good advice, because on our end, I think I have been blowing that off, thinking I'm not going to get a fair shake, when that's kind of unfair to the carrier side, because I'm not giving the information that I'm already assuming I'm getting a short take on it. And then it also helps that, if I get a excess verdict and somebody like you are looking at the file and be like, good Lord, guys, he had something like a 6-page demand letter with pictures and stuff like that and everything. And, like we had an idea what we were dealing with here. Like this wasn't, this was a solid plaintiff. They were going to present well.
Yeah, no, it can, that's the flip of it. It can also be a tremendous exhibit for you guys.
Yeah.
In the bad faith case, because you can say, look, here's what I told them.
Yeah. This isn't a surprise that they volunteer with the the armless orphans every Friday, and
right. Exactly.
It's all here.
He's telegraphing this stuff the whole time. This was his opening and closing statement right here in this 6-page demand.
That's right. Oh. And you may say, well, they're not going to listen to it, or I don't want to give it all away. And it's just your strategy, I guess, whatever you want to do.
Yeah.
But I do think, like I said, giving them everything you have, including stuff like that helps cases get resolved.
Good. Very good.
Well, we're about at an hour. There were other things I wanted to talk to you about, including like, what's extra contractual versus what's actually bad faith and all those, because I kind of see that sometimes, but we'll have to maybe take that another time. But, I do appreciate you coming on here. And I will say, for those that are looking to connect with Mike Young, LinkedIn, I think, is a great spot to find you. I think that you've done a very effective job of humanizing insurance industry, but also pointing out some of the issues you have with it, which it's cool to see, because I'm like, well, okay, that guy deals with it on a daily basis, but you've effectively managed that social media. And so I guess I would like to leave it at that for somebody like you, who's kind of a business to business type consumer person.
Right.
How have you seen that help you at all? Things like that.
I started doing that, 5 or 6 years ago, when there weren't many people doing it. And I just did it because I'm not saying it's right, but like, I do like the coverage stuff. I think it's fascinating. And, I thought, well, I'm just going to go on the computer and just type some insurance stuff and see if anyone responds. And, so I would post something and I'd get 5,000 views.
Yeah.
And I'd post on some other arcane covered, I'd talk about the duty to defend, 8,000 views. I'm like, what is going on?
Someone's watching this. Yeah.
Who is paying attention to this?
Yeah.
And then over time, I figured out, oh my God, this is a tremendous, B2B marketing thing.
Yep.
And I didn't start it that way. I just started because I thought it was kind of fun. And since then, in the last 5 or 6 years, it's just exploded.
And you're seeing returns on it. Like you're seeing more. insurance professionals reaching out to you, maybe retaining you guys, stuff like that, or getting the coverage opinions?
It has, Chris, and it's funny because like on our side of things, so much of pre-social media marketing was conferences. And going to DRI or going to COM, and you meet
going to dinners with everybody and all that.
Going to dinner, that's right. You're going to give a speech, and a lot of this, it's so political if you get to talk and all this other nonsense. And LinkedIn, you just go straight to the people.
Yeah.
There's like no filter, which is good and bad, I guess. But you can just talk to people and have conversations, and it's gotten a lot of attention, and I never imagined it, but it's been really good for our practice.
Yeah. And it's something I would like for our side. Obviously, when we're straight to the consumer, we think, oh, well, if you post, consumers will see this. But I never really thought about it from your guys' side.
Yeah.
Until I saw you effectively doing it, where it was generating traction, it was generating engagement. I thought, man, he's speaking to a niche population, right?
Very niche. That's right.
Yeah. But they're responding. And I was like, all right, the riches are in the niches. Like, you just keep honing that. And then before you know it, you have the chops to back it up. You're the go-to guy. And it's like, hey, let me address this issue. People are in your direct messages, sending you stuff, and it turns into a generator. You did it all from your home office or wherever. You didn't have to go to Las Vegas and be like, my God, it's 10:30. We haven't even eaten yet. I mean, I gotta
right. That's right.
I'm gonna go jump off a building here in a minute just to end this.
I think we have happy hour at 11:45 or whatever we're doing. Yeah, exactly. So I mean, it just took off. It was unbelievable. But like my 14-year-old would tell me, she's like, Dad, it's not like you're a YouTube star or anything. So, like, okay.
Insurance world, I mean, look, in the insurance world, I would argue the opposite. It is definitely helped. And from my point of view, personal point of view, it has helped me take a better view of insurance professionals, because too often in our side, on the plaintiff side, you can get embittered and thinks things aren't necessary. Yeah. And you're just doing that because you have some protocol to follow and this case doesn't fit that protocol and blah, blah, blah. But the humanizing of it has helped me, at least, I don't know which, it depends on the adjuster you talk to, but at least communicate more effectively with them. And in the end, the content you're putting out is beneficial in that way for a ton of younger lawyers coming up that can see it and say, all right, I may be opposite of that, but there is effective communication that can go on. And we're all kind of talking about the same issues,
right?
Claim notes, things like that, it's out there.
Yeah. And that's what I like about it. And you do get like policyholder people who engage on this stuff.
Yeah.
And for the most part, it's pretty respectful.
Yes, it is. And that's why I like the LinkedIn. It is more respectful. It's more professional. And
it's people trying to figure stuff out. And and I've heard the industry people, like it. Doing like bad faith and EC review on claims, for the most part, I mean, these guys are just trying to do their jobs, and sometimes they screw it up, and that's a problem. But I've only seen in 20 years, maybe one or two times where I've looked at a claim file and I'm like, well, hell, this is real bad. Like, I do think they were trying to screw somebody. Like, maybe that's happened like once or twice, and when you see it, it's like, my God.
This looks horrible.
You're just like, wow. But 99.9% of the other stuff, it's not even close to that. It's people making wrong decisions, people making mistakes, people forgetting, people, whatever it is. And, so that's our job, to try to humanize these guys and explain, like, no, they do have a difficult job. They're trying their best, et cetera, et cetera. So that's a part of it too.
Well, I got to tell you, I appreciate you coming on. I appreciate you sharing as much as you did with us. I think it's definitely helped us. The perspective is really, it's refreshing to see. I think if we had more engagement like this, we'd be better off. And your reputation does precede you in that this is your approach in all the cases, why you were able to resolve a lot of these issues without massive damage,
right?
Depending on when you come in on the case is the other problem, but yeah,
that's right. My goal is to stay out of Missouri Lawyers Weekly. You guys want to get in it? I want to stay the heck out of that thing.
Hey, I've been in it without approving it, so you can guess why. Yeah, that's that. I didn't want to be in it for that reason either. But.
Yeah. So Anyways, Mike, how can people get a hold of you if they're looking to reach out or they got some issues or, want to talk about something?
Yeah, probably, just go to LinkedIn, look up Michael Young. I'll be there. I do have a little website, www.michaelyoungstl.com, which will just flip you over to LinkedIn anyway. So those are a couple good ways to get a hold of me.
Perfect. Awesome. We appreciate it.
All right. It was a good discussion, guys. Really appreciate you guys having me on.
Likewise.
You're listening to the Case Autopsy, the Verdict and Settlement podcast. Here's your hosts, Mike Campbell and Chris Finney.
You can see why you're excited when, or you at least are intrigued whenever he gets involved in a case.
Yeah, I mean, he's coming in when there's some real concern on the other side, and plaintiff lawyers like that. And I think for me, what I took away from him today was, number one, our my tone or the way we communicate with the other side can improve, but the demands. He talked about the demand. Like I've been in a thing probably the last 2 years. We just get him out the door because I didn't think adjusters were looking at him, and he's telling us they can make a difference.
Yeah, but I mean, I go through those funks too, Chris, where I'm done even trying with, and I'm just going to file everything, and we're going to find out if human damages are a thing, or we're going to find out, So I get on these kicks, but as I said in the beginning, and as I kind of talk with him, sometimes that's not what the client wants or is in the best interest.
You're right.
And what if we were able to, you're really good at this, and you always provide some sort of leveling force for me anyway. And that is, what kind of lawyers do we want to be? And do we want to be tricksters, or do we want to be like, hey, let's do this the right way? What does that look like?
Yeah. Well, this was, I appreciate that. And this was a good discussion. He's definitely a good guy on the other side, and hopefully people had some takeaway from it that can help them. Certainly, I think going to help me. Absolutely.
And it's funny because I always, I know we have tribes, right? And it's funny, I could feel myself whenever he's talking about like how, the plaintiff's lawyers can do this thing. And I remember the Capitol when they're talking about clever plaintiff's lawyers doing this other thing. And I don't think he meant anything by it or anything like that.
No. Yeah.
But still, I'm like, that's my tribe.
Yeah.
I must
like, hey man, and that's not how really. Let me show you how that goes down. But
right.
yeah,
I must speak for tribe now. Yeah. And so it is interesting because I think for the most part, I know you do it the right way, and all the people I run with do it the right way. We're just trying to get our people help, and I know that Mike is doing everything he can to give good advice to insurance companies too. So it's good to have him on.
Yeah. Awesome.
That concludes another episode of Case Autopsy, the Verdict and Settlement podcast. Part of the Lawyer Minds ecosystem. Thank you for listening, and we truly hope it was worth your time. Please consider subscribing to the show wherever you listen to podcasts. Explore the other content that Lawyer Minds has to offer, and engage with us on social media. Your feedback and ideas are always welcomed. See you next time.